Okay, this is the February 10th, 2015 continuation hearing in Lucas County Zoning Board of Appeals review of Lucas County zoning case issue 714, Pleasant Ridge Energy LLC, Pleasant Ridge Energy Project. Michael Cornell here, John Ditson here, Richard Keeper here, Diane Iverson here, Howard Zimmerman, Joe Newsman here, Gibbs Nielsen. We have a form.
All right, certainly like to welcome everybody back this evening. Need to take care of a few housekeeping items. Got a few exhibits that we didn't get admitted in evidence. The first exhibit, UCLC Exhibit 60. It's the resume of Aaron Nathaniel Bruin. Next exhibit, UCLC Exhibit 61. That's going to be the comments, findings, and conclusions about report by David G. Loomis, PhD, of Strategic Economic Research, LLC, entitled Economic Impact of the Pleasant Ridge Wind Energy Project. Next exhibit will be UCLC Exhibit 62, and that's the economic and fiscal benefits of the Shady Oaks Wind Farm. All right, we've got that taken care of. Okay, we've got a couple more. Pleasant Ridge Exhibit 300. This is the energy.gov website. VP 100, Illinois Wind Farm breathes new life into businesses. The next is Pleasant Ridge Exhibit 301, entitled Illinois Wind Energy. Illinois has been successful in attracting investment for wind energy manufacturing and large wind energy projects. Pleasant Ridge Exhibit 304 is an ex-post analysis of economic impacts from wind power development in U.S. counties. All right, with that taken care of, had an individual talked to me last evening after the meeting. He had testified. Mr. Kelson is out there. Yeah, if you could come forward. There was one point of clarification he just wanted to make in his testimony or his cross-examination. He felt it was worthwhile to tell us, so you can either come here.
Thank you. I'll just read this real quick. After I sat down last night, it occurred to me that my response to Patrick's question, he had asked me a question regarding my knowledge of the possibilities of a wind farm coming to our area, may have been a little bit misleading. Didn't intend it to be, but I think it may have been. My response to Patrick when he asked it was, we had heard at one point that they'd be building to the north there by Odell. I guess it took us off guard when this application was turned in. That was my response. I feel that mentioning Odell is misleading because in 2007, when we purchased the property, we were told that wind turbines could come as far south as the ridge north of us, but that the valley where our property lay would not be an option to them and outside the footprint. In 2011, when we prepared to build our home, we were under the impression that the project had died. We were certainly surprised by the project resurfacing, but I apologize for making it sound farther than it was last night. Thank you for allowing me to clear this up.
Thank you, Mr. Clark. Just real quick, Mr. Luke, has a question for him? Any questions? Other members of the ZBA regarding this statement? No? Okay, Mr. Blazer, do you have any? Okay. Audience, is there any questions specifically about his statement that he just made? Units of local government, county staff. All right, thank you, Mr. Kelson. All right, with that, I believe we will move on. Mr. Lukans, I believe you have a witness with you this evening.
Yes, Mike McCann.
Mr. McCann, could you please raise your right hand? Do you solemnly swear that the testimony you shall give in this case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, can you please state your name and address for the court report?
Michael
McCann, spelled M-C, capital C-A-N-N. My business address is 500 North Michigan Avenue, Chicago.
Mr. McCann, you may continue.
Thank you.
Mr. McCann, I know you have a presentation. We'll get that fixed up in a second. 1 second, I'll ask you to present.
Close enough to the mic? Shall I begin?
Yes, please.
Good evening, Mr. Chairman, members of the board. As you know, my name is Mike McCann, I'm a real estate appraiser.
You know what, I apologize, Mr. Blakeman, Mr. Cornell. We have submitted some exhibits, and I just wanted to mention those, some of which will come up. They're all relevant to his testimony, but the first is UCLC Exhibit 71. That is the PowerPoint presentation he's about to give. Second is UCLC Exhibit 72, which is an article by Albert R. Wilson. The third is UCLC Exhibit 73, which is the professional profile of Albert R. Wilson. The fourth is UCLC Exhibit 44, which is a Lansing, L-A-N-S-I-N-K, case study. UCLC Exhibit 74 is an MPAC, or Municipal Property Associate Corporation study. Exhibit 75 are affidavits and information that were filed under oath in front of the Public Service Commission of Wisconsin. And Exhibit 79 is a property value guarantee agreement. I apologize, and please proceed, Mr. McCann.
Thank you, no problem. The reason I'm here tonight, in a nutshell, is to talk about property values and the impact from wind energy facilities on neighboring property values, and more specifically to the Livingston County zoning standards for approval of the special use that relate to impact on property values. The first slide you see here, you may have heard the name before, is the residence in Michigan belonging to Carrie Schitteldecker. And the reason I think this is significant because, again, in a nutshell, what you see is what you get. And even though that looks like it's right on top of the house, it's really over 1,100-foot setback from that property with a 476-foot height to the top of the blade, the tip of the blade, excuse me. This is also a property that I had some experience with going back to June 2011 when he first started trying to sell this property. Before the application for the wind energy project there had even been filed, and he just recently closed, finally, on selling that property, very close to my forecast, and lost about 35% of what the market value of the property would have been without the turbine present. He had marketed that extensively, and as I recall, at the last count, there was something on the order of over 25,000 internet hits. The property had plenty of exposure, and it just takes a very special wire to absorb that kind of risk. This is just one example, which I'm going to get into a lot more. It's been a while since I've testified before this board. I'm not sure if it's any of the same members or all new members. I figured if you're not remembering all the names and faces, but I did testify previously on the Deer Run project. And just briefly recap my qualifications as an appraiser, and more specifically for measuring wind farm impacts. I have 34 years experience appraising and consulting on really every type of property, from residential to farm properties, commercial, industrial. I'm a state certified general real estate appraiser, licensed by the state of Illinois. And for those who don't know, that's the highest of 3 levels of licensing offered by the state. I'm also a certified review appraiser. I was inducted to Lambda Alpha International on the basis of my expertise in property value studies. It's not something every appraiser does, but it's a little bit of a niche I've developed, not just with wind projects, but really measuring any type of land use impact upon another. I I've previously qualified and testified as an expert witness in over 21 states, including well over a dozen counties in Illinois and federal courts, and I've appraised, again, a variety of property value damage situations that ranges from impacts such as these to road widenings and takings of partial portions of parking lots from shopping centers, things like that. It's, again, an area of appraising that many appraisers don't get into, but it's something that I have found myself doing more and more as the years go on. I haven't done this just for objector groups. I've worked for governmental bodies, developers, corporations, attorneys, investors, and private property owners. In fact, I was appointed by the Northern District, the U.S. Court, the federal court, as a condemnation commissioner for a pipeline project that went through Will County a number of years ago, called the Northern Border Pipeline. And it was my role, my job as a condemnation commissioner, along with a law professor and an attorney, to make a recommendation to the court as to the just compensation to property owners for the pipeline being routed through their property. More on point, I've evaluated well over 20 utility or industrial scale wind projects in over a dozen states. In the back of my more lengthy report, not the presentation, is a summary of, I believe it's an updated summary of most of the ones that I've given sworn testimony in. And the Appraisal Institute, who you may know who they are, the organization has invited me back in 2012 to develop and present a seminar on this very subject, the effect of wind turbine impacts on property values, which I did. And while I'm not a member of the Appraisal Institute, they sought me out to prepare the seminar, present it to the membership, and the seminar was peer-reviewed by the Appraisal Institute's Education Committee and approved for education credits for the members of the Appraisal Institute. Yes, sir.
Stop right there. You're struggling.
Yeah, I'm going to move.
Okay.
I just want to get
Take your time.
Jim, what do you need? Do you need power? Do you need anything? Okay. All right, Mr. McCann, go ahead.
Thank you. This next slide is just basically the cover of that wind energy seminar that I prepared and presented to the Appraisal Institute. We'll go through the summary of my qualifications, which is on there again. In this specific study, kind of getting right into the meat of things, it's the steps I took to develop a new study in Livingston County. Started with a review of the Livingston County ordinance, more specifically Chapter 56, the zoning chapter, and the special use approval criteria that's contained in there for any special use.
Mike, let me interrupt for 1 second. I think in the back of the room they're telling us they're having a hard time hearing you, so if you could try and get that mic a little closer. Thank you.
Is this a little better?
Yeah, I think so.
To continue, I also reviewed the existing character of the project area, which is, as we all know, primarily agricultural and rural residential. And then I reviewed the nuisance factors and the stigma from nearby wind projects, and for that matter, other wind projects throughout the United States, as to the nature of the conflicts with other land uses that are often created by large-scale wind turbines. Then I developed an empirical value study, and by empirical I mean I was looking for the facts, and I found them, and I'm going to get to that more in a minute, and then it's the extension of those facts is the basis for my opinion. But I also know I'm not the only person that's ever looked at this, or the only appraiser or person purporting to have actually studied wind farm impacts, so I did a literature review, and that's been really, frankly, ongoing over the last 8 years plus. And I'll talk a little bit about those in a few minutes too. I don't need to spend much time on this. You've probably all seen this map. This is the outline of the Energy Pleasant Ridge wind farm project area, extending from southeast to Pontiac down to kind of encompass one town and adjacent to a couple others. Let me point out that I specifically did not look at the property values in the smaller incorporated towns. I focused on the rural residential. So the data I'll talk about all relates to that. The primary portion of the zoning code that I looked at is the special use standard that is relevant to real estate appraisers, and which would require this board to have a finding to approve the project that the special use or the proposed special use will not be injurious to the use and enjoyment of other property in the immediate vicinity where the use is already permitted or substantially reduce the value of neighboring property. This map might be a little hard to see from your vantage point there, but this is a map of my value impact study area, and you can see down at the bottom of the map the Pleasant Ridge project area, which that's not an exact outline, which is the land. But above that to the right, you can see the Coyote Ridge project, and all the red dots represent turbines that this was all derived from the USGS maps, so it's not something I created per se. I just imposed it onto this slide. There's also the Mononk project. While it overlaps into Wolford County, it also is partially in Livingston County. And then the Grand Ridge project at the northwest part of this map, while it's getting kind of close to Livingston County, the nearest turbine is actually set back at least 3 miles from the county line. So there was no sales data that I drew from proximity to the Grand Ridge. But the Top Crop project, again, while it comes down to the county line, is not actually in Livingston County, but there was some sales data just south of the Top Crop project that is part of the basis for my opinion. So just to be clear, the red dots represent the turbines. The sales data that I've identified as target sales come from within 3 miles of either the Mononk, the Coyote Ridge, or the Top Crop project. What causes value loss? There's a host of things that can impact value, and sometimes or often do, depending on the siting and the proximity. Detrimental conditions can include any number of things, including land uses such as wind turbines. It also can be caused by the impairment of the quiet use and enjoyment of the property. This could be a motivating factor for people to sell, for example. Bona fide nuisances and health impacts, while there's always attempts to minimize what people have experienced, testified to, stated in any number of forums, this is so widespread that having been looking at these projects going back as far as 2005, I know there's no conspiracy amongst neighboring property owners. It's a widespread trend that these impacts do occur near many wind projects. I'm sorry for getting feedback here, I get too close. Stigma is a recognized real estate term. I have a definition for it later in the slide, but it essentially means the loss of reputation of property. And again, I'll get into that a little further, but it can include aesthetics, it can include things that are more physical in nature, any trespass or intrusion of excessive noise, contaminants, odor, vibration, glare, flicker, or physical impacts into, through, or over neighboring property. Again, stigma essentially constitute damage to the reputation of the realty or the real estate, and that comes from a Kentucky court case. It's not my definition, but the link is there to see exactly where I derived it from. The property value studies, this is not the first one I've done. I'll talk about a few of them, mostly about the Livingston County study. And again, I've also reviewed a number of industry studies which have been prepared by academic institutions such as Illinois State University. You've probably seen a couple of them, the Jennifer Inman study, the Jason Carter study. And some were funded by the U.S. Department of Energy and wind energy developers, which whether or not you're aware, the ISU Renewable Energy Program does take corporate sponsorship, and they get some input into how these studies are derived. So while these students are preparing their theses, how to put it, they're not just independent objective experience studies. These are students preparing theses that, to achieve a renewable energy degree or certificate, which in part is funded by various wind energy companies acting as donors. One of those studies, not an ISU study, but the Berkeley, the original Berkeley study, commonly referred to as the LBNL study that was done in 2009, published in December. But one thing that really shows a high level of statistical significance is their analysis of views or vistas from property. What's the setting? And as you can see on this figure ES2 from their original report, we have a premium vista on the far right. The properties, and they had a number of 75 sales in their study that showed 13% higher values. And above average vista, again based on well over 400 sales, is a 10% premium. And the reference category is just a fairly typical view from a property or vista that goes more to the aesthetics than any noise issues or anything like that. But further to the left, you can see when you get a below average vista or poor vista, then the sale prices drop significantly, 8% and 21% respectively. So if you start off with a property that has a premium vista, a wide, spacious view, very natural setting, you might, according to their study, obtain a 13% premium above a more standard vista. And if you take that vista away and turn it into a poor vista, you now experience a 21% loss. So by their own study, you can see that just by view alone, you can end up with a 34% swing in property values, and that's not taking into account any wind turbine or other focused study on that point. But clearly they recognize, as does the appraisal community, as does the real estate industry in general, that views definitely translate into value. But those are statistical studies, which are not prepared to the same standards as a qualified appraisal study. They are, in fact, while they use the term value, they steer pretty well clear of claiming that their value studies, they're statistical studies. The correct way to objectively measure any value loss from a detrimental condition can be found in a textbook, Real Estate Damages and Analysis of Detrimental Conditions, prepared by, authored by Randall Bell and published by the Appraisal Institute. And what Mr. Bell clearly recognizes is pure sales analysis of properties that don't have the proximity to the land use in question or the issue in question, and compared to other like properties using appropriate appraisal methodology and paired sales, you can derive and extract on a very focused basis what the market is saying about value as it relates to, again, the use in question, which in this case is the proximity to wind turbines. The regression studies, or the statistical analyses that, again, the institutional is the preferred method for the institutions, are not really reliable for damages estimates or for finding if there is any damages. There's a host of reasons for that, but the IAAO standards, and that's the International Association of Assessing Officials, has standards for using regression analysis when they're preparing sales ratio studies. This is also codified in Illinois law as far as the minimum level of a ratio that's acceptable, often called assessment sale ratio or sale ratio studies. And for assessors who are doing mass appraisals of properties throughout a county, that standard is at least 85% or 0.85. And that correlates more or less to what the statistical studies use as their primary measure of reliability, and that is what is statistically referred to in the statistical world as the R-squared. And while I'm not an expert, I have no degree in statistics or anything like that, I have studied up on it enough to understand it well enough. What the R-squared really means is it's a coefficient of correlation, or what is the explanatory power of their study. And the statistical studies prepared by Berkeley and Illinois State students and so forth, they typically are in the 0.5 to 0.6, 0.7 range. In other words, at a 0.7 R squared, it only explains 70% of the variation in sale prices, and it just doesn't even come close to meeting the standard for reliability required in other government studies, meaning at the county level for property values, that again corresponds to the assessment sale ratio. It's really desirable to have above 0.9, 0.95 by the IAAO standards. I do use things like averages and so forth, but more traditional and understandable statistical terms. This following exhibit, the target sales location map, again, you can't see it too well on this, apologize for that broadcast up on this wall, but the red balloons represent the location of turbines, and the green ones represent the location of the target sales. In other words, the sales that I found that were within 3 miles of those 3 projects, the Mononk, the Cuyahoga Ridge, and the Top project, and which were sold conventionally. In other words, these are not the foreclosure sales, these are not the state sales or other sales that would be rejected as not being arm's length transactions. I'll get into the control basis in a minute, but the study results, as you can see on this table, is the bottom line is overall it showed that the data it finds almost 25% lower value within 3 miles of turbines compared to control sales that are located more than 3 miles away. I'll just walk you through it briefly, left to right on this slide. The sale number, you can see T1 through T17, and that means that there were 17 sales that passed the vetting process, again, by eliminating foreclosure and so forth. So these are all arm's length sales. And then in the next column, you can see the number of control pairs that were paired up with each of those sales. And then there's the average price per square foot for the target sales versus the control sales, which was 23% lower in the target locations. And the marketing times were about 21% longer in the target locations as well. The far right 4 columns, that's really a basis of taking each of those control sales and making appropriate adjustments for the differences with the target sale except for the turbine. So it solves for all the other variables, at least the ones that have a measurable impact on value. And that includes the age, the size of the property, meaning the square footage of the homes. It also includes the acreage of the parcels. And each of the control sales were selected on the basis of also being rural residential, more than 3 miles from any turbine, or for that matter, the landfill near Pontiac, and excluding foreclosure sales again. So each of the control sales were also selected on the basis of being within a few months of the target sale date, so there was little or no adjustment needed for changes in market conditions. It kind of would be very nominal with a 2 or 3 month difference. So each of those sales is paired up with groups of control sales that occurred at the same time and then refined further by the physical features of the property. And when all that is done, you can see at the far right side the impact fair market value percentage, what each one of those paired sale analyses revealed as far as the impact measured from that particular sale. And the bottom line for that study area overall, again, is a 24.68% lower property value. I also looked at it.
Mr. McCann, before you go on to the next slide, let me ask you a question. So just so we're clear, on the left-hand column, sale number, those are all sales within the target area or target areas?
That's correct.
And then the control pairs are sales that you thought were comparable but were outside of the target area or in the control area?
That's correct, yes.
Okay, so you compared those 2 types of sales, and made modifications based on the type of property, the size, etc. And that's the same kind of modifications you make whenever you do an appraisal, correct?
Well, the technical term is adjustments, but yes,
Yeah, sorry.
and adjustments can be quantified or qualified in some cases. This type of study lends itself to doing quantified adjustments, which is exactly what it did.
Okay. No, please proceed. I apologize.
No problem. I also took an excerpt out of that overall study to kind of test out what the Hinman study found, which was approximately 12% pre-construction, what she termed wind farm anticipation stigma. I think she came up with a theory. She certainly claimed the credit for it in her 2010 thesis report for ISU. And I did find a few sales that were, the property had sold before the project was built, after it was known or the project was announced. So when people in the local market area knew it was coming, how was that affecting the sale prices? And that's what this table basically answers. And while there were only 3 that met that criteria, it actually matched up very close with what Hinman said on pre-construction anticipation stigma of about 12.73% lower near the turbines, near where the turbines will ultimately be. Sometimes we don't really know exactly where they're going to be, or they're going to be on a certain property, but not on a very discrete, specific part of the property. They get moved around sometimes.
Mr. McCann, would you agree that the Hinman study found an effect in 2 of the 3 counties and no effect in the 3rd?
That was the Heinzelman study.
Oh, I apologize.
That's all right. Trick question from...
Yeah, from your own attorney. Yeah. I apologize. Please proceed.
The Hinman study only looked at property values, or attempted to, by the Twin Groves wind farm in McCann County, and the one he was referring to was out east in upstate New York, the Heinzelman Tuttle study by Clarkson University, also a statistical analysis. These sales kind of bear out what happens after the project is built, and it eliminates, or excludes, I should say, those pre-construction sales. And as you might expect, once you reduce the lower percentage, it does in fact raise the percentage impact on a post-construction basis. And that's 27.25% by this study of property values right here in Livingston County. Also, as I was going through the data and poring over it for many hours, what I was noticing is that there seemed to be a higher level of foreclosure nearest the turbines, and that in fact turned out to be true. The information came from both the Livingston County MLS and the Midwest Real Estate Data MLS, which is something that is used more in the immediate Chicago area, but does not include everything that's in the Livingston MLS. So we spent quite a few hours merging those 2 databases together to make sure that we had picked up everything that had gone through realtors. And then we in fact signed on to be able to use the county assessor's website, and we're able to confirm things that were reported as foreclosure sales or in fact confirmed as foreclosure sales on, again, on the county website. And here's the bottom line is that for the years once the turbines were starting to be built, and through this is through late November of 2014, out of 151 sales, more than 3 miles from any turbines, 16 of them sold by foreclosure or short sale, or about 10.6% of the total. On the other hand, out of a total of 30 sales in the target area, 9 of them sold by foreclosure or short sale, or 30% of that total. So in other words, within 3 miles of turbines, there are foreclosure sales at 3 times the rate that you otherwise experience for like-kind properties that are more than 3 miles from turbines. This is consistent with the reports you've all heard of people abandoning homes. Abandonment comes in many shapes and forms, but walking away from a property, letting the bank take it back, or selling a short sale is certainly consistent with that premise and those experiences. There's been other reports of people walking away, doing nothing. And Mr. Schitteldecker, that slide I showed you at the beginning, him and his wife, who I met, and appraised their house back in 2011. And they loved that house. They didn't want to leave. They were drummed out of there by the noise, having had to move their bedroom down to the basement because of what they described as the low frequency bumping that they could feel, in their body, and causing all kinds of sleep deprivation and other, right down to dental issues, gritting the teeth while they're sleeping, and loosening teeth. But he has in fact now left that house, despite the fact he didn't want to, his wife didn't want to. This is going to be real hard to read from there, but it's in my report. In fact, there's several pages of these paired sale analyses. These are the details that I summarized previously. And I'm not going to bore you with going through every one of those. It's okay to breathe a sigh of relief, but I just want to explain to you briefly what it is. This is kind of what an appraiser would use, similar in a form report that they're doing for a lender. But I've modified it some to for this particular situation. In the upper left corner of that paired sale analysis, you can see that that's T2, meaning that it's target sale 2. It's by the Mononk wind farm, and the nearest turbine is, in this case, 0.58 miles from that particular residence. And then the line that's in green, that is all the details of that sale, the address, the mailing address, meaning city, the date it closed, the sold price, the dollar sold for per square foot, how many acres the lot is, the marketing time, and so on down the line. And then beneath that in the black font are in this case, 6 control sales that I paired up with that, each individually, as if I was appraising that particular target sale using these comps from more than 3 miles away. And beneath each of those sale lines, on the sale lines, you can see what the comparison is, and then the adjustments I made for those different factors. So if it was a larger property, there was a downward adjustment for that factor being superior to that target sale. And then at the end is the result of the net adjustments to each sale and the adjusted value, and then the impact percentage that is derived just mathematically from the analysis of that sale. In the lower left part of that paired sale example is just the raw facts, what the control mean sale price was, what the target mean sale price was per square foot, and the difference in a dollar expressed as dollars and as a percentage, which in this case is 26% lower. And then over at the far right side of that left box, you can also see the marketing time difference. The far right, the lower box is the fair market value analysis that shows what the fair market value of that target sale would have been, but for the turbine, what the actual sale price was, and what the actual value impact amount was as a dollar amount, and again, as a percentage. This was repeated until we went through all the target sales that were not foreclosures and that were on larger than an acre lot. And I had to exclude 1 or 2 others because they just couldn't comp out. One of them had a church on the property, for example, and that would start getting into some speculation as to what would be an appropriate adjustment for a house that's sold and also had a church on the property. This is not the first time I've done a study of property value impacts near turbines, but it's obviously my most recent study. I had done one in 2009 for Lee County when all we still had there was the Window to Hills project. And it was just more of a simple array of the data that had sold in 2003 and 4 and so on, shortly after the project went up. And what I found was that sales that were located more than 2 miles, and I used a 2-mile metric at that point, averaged $104 a square foot. And the sales located within 2 miles averaged $78.84 a square foot. There's the details. Anybody can check out. It's transparent, which I might add is somewhat unlike the statistical studies that you can't identify a single property. But that early study that I did found that, in fact, the average value diminution within 2 miles of turbines was 25%. No adjustments made. Again, just a rather simple array of the data by distance. I also had the opportunity to update that study and expand it into DeKalb County after the Florida Power and Light project was built in DeKalb. And again, I did a detailed pair of sales analysis with the target and control data, selected on the basis of proximity to the turbines or being much greater distances, which in that particular case, the target sales averaged a 2,618-foot setback from any turbines. And the control sales on average were over 10 miles away where you really couldn't even see the turbines. Sometimes the control distance is questionable because you can see these from a great distance, and when you're looking at a turbine from 5 miles, it doesn't look like any big deal, but from 2,600 feet, there's a large part of the market that disagrees with that. But in any event, what that data found was that there was a 23% to 33% reduction in value at the closer setbacks, and it averaged at 26%. This is a different format with the same type of study. Target sale on the left, control sale on the right, and you can see the photographs. They almost couldn't be any more cookie cutter in this particular example than those. But what that one showed, and from the DeKalb study, was a 43%, over 43% impact on value. While this table summarizes, broken down by Lee County and DeKalb County, for the target and control sales. I won't repeat everything that the table shows, but it does show, in this particular example, a much longer marketing time, almost exactly a year to the date for the properties in the target area that sold versus the control area. What it also showed was sale prices, the percentage of list prices, only 70% near the turbines versus 91% from that database far from the turbines. The closer proximity and the bigger turbines, but I really noticed the proximity, did show a greater impact in the DeKalb study, which, as you can see, that averaged out to just under 33% versus just under 23% in Lee County. That 22.5% in Lee County, I think, is worth spending just a few seconds on. I've often heard the claim that once the projects are built, people get used to them when the property values recover, and many even went so far as to say that they soar after the projects are built. That project has been up since 2003, and I don't see values soaring. I still see a significant drop in value, 22.5% in Lee County, a decade later. So the facts belie the PR. And that's pretty much what I just said, so we'll just skip on past the rest of that slide. I haven't just worked in Illinois. This is a brief, spent a very brief amount of time on this. There's very little data by the projects where those two stars are located, the big red stars in Union and Hoagland townships in Van Wert County, Ohio. Very rural area, very low property value base, definitely a farming community. And what I did there is I enlisted a local realtor to provide all the sales data since that wind project had been built. I'm trying to remember the name of it, I think it was Blue Ridge or something like that. They always have a very pleasant name, but in any event, the Union and Hoagland townships is where the turbines were built. And I compared it to the sale prices in Liberty and York townships. Which again, what we see is a preponderance of foreclosure data, which in this case I didn't extract it from or vet it out of the database. This includes foreclosures, just to be clear. But what that was finding is in the townships more than, or the section more than 6 miles away from any turbines, the average sale price was almost $79,000, while it was about $58,000 in the turbine township. A 26% lower value near the turbines. If you look at it on a square foot basis, 22% lower. There wasn't a large number of sales, I'll admit that up front, but billions of dollars are loaned every year on homes with based on appraisals that have 3 or 4 comps. So when you hear someone say that, oh, this study had 50,000 sales in it, I have to answer how many of them are relevant and how many of them can we identify. And frankly, the answer is not positive to either of those questions. I don't want to put everybody to sleep, so I'm not going to go through the entire details of this particular period sale analysis. I've done a little work out in Massachusetts too, and that was not a large-scale project. There was actually only 2 turbines built on the Falmouth, village of Falmouth, or town of Falmouth, wastewater treatment plant, and a property right across the highway from it that sold, but where the visual impacts, the noise impacts, and so forth were being experienced, as well as some of the other residential area around the wastewater treatment plant. But the bottom line is this particular period sale, again, found a very consistent reduction in price and value that is related to the proximity of the turbines. I mentioned a while ago that I'm not the only one that has done these type of studies independently. There's a gentleman up in Ontario, London, Ontario, by the name of Ben Lansing. He's a professional appraiser in that part of the world. And he was picked up on some sales that I'd learned about years ago, but many things happened since a few of those developer buyouts happened. The properties on the right of that table are properties near what's called the Langton area in Ontario. And the Canadian Hydro was a wind developer that built a number of turbines in that immediate area. A number of people had started experiencing noise and those type of issues and sought to be bought out. Canadian Hydro, in fact, bought them out. And they bought them out at what amounts to market value that Mr. Lansing's study pretty well proved up that the original price that they paid was not some inflated windfall to the property owners. They bought them out at market. Then the developer turned around and resold each of those properties using conventional marketing methods, the multiple listing service up there. The kicker was, and this is what I really like about this data for understanding the issue of property value impact as it relates to the definition of market value. Anybody that bought those properties had to grant back to the developer an easement that was labeled an easement and gross that clearly identified that the wind turbines exist, that they may impact the living environment of the property these purchasers were going to buy, and that the developer, who's now the seller, reserves the right to broadcast noise, flicker, shadow, vibration, and those type of impacts that are commonly identified and experienced. So each of these buyers had full disclosure. This is not a case where anybody of those 5 people or that one developer were not giving full disclosure. That can be a problem with sales sometimes, identifying what did the buyer know, what did the seller know, what did they talk about, what did they tell each other. It's recorded in the county database up there that these in fact had the easements and gross in them. In fact, in my report I include a copy of the standard easement and gross that was used up in that project area. Again, very clean data from the perspective, it's unquestionably market value transactions. And this is how Lansing basically did it. He determined what the market was doing at the point in time that the property was bought out, and at the point in time that it resold, and he adjusted those sale prices according to how the market went, and then saw what they actually sold for, deducted the difference. You get a dollar amount, you get a percentage amount that corresponds to how much value that property actually lost in light of the prevailing market conditions outside of the turbine area. I'm not going to take that up for everybody to try to read it. I think it's kind of fine print, but it's there in the PowerPoint. Winding down a little bit, this is kind of a summary of a number of the studies that I've just talked about. There's some I haven't mentioned, like the SUNAC. That was a study done at a university. I'm going to try to pronounce it in Germany. And it was, again, a statistical study, much like the U.S. Educational institutions usually do. But despite using statistical analysis, he found 25% impact to lot values within 2 kilometers of the turbines in Germany, which many were of older vintage, smaller, not as dominant in the landscape, or I imagine, in the noise that it produces. Beneath my name, the bottom part of that slide shows the Gardner results, and he's an appraiser down in Texas, and using paired sales methodology of ranch properties, he found a 25% impact on values. Kirk Kalish, appraiser in Wisconsin. In fact, Mr. Kalish and I both spoke during the Deer Run hearing a number of years ago here in Livingston. And but what his study found is, depending on how you look at it, and which analysis referring to, including a regression, 30 to 40% or 24 to 39%. Not a specific number, but by, I think, this measure a significant difference in values. The Luxembourger study is really more of a broker analysis, but he used a decent methodology, near and far, and what he measured compared to beyond 3 nautical miles, nautical miles, because he's a pilot as well as a broker, and what he was finding was property prices $48,000 or 15% lower, without really doing much more study than that. But he had a large database. It was relevant up there. The Lincoln Township Committee, this was a government body, the moratorium committee, I believe, what they compared was assessed values, again getting back to the assessment sale ratio type of analysis, versus what compared after the wind turbines were built up there, I believe the Forward Wind Energy Project. And if you compare what the assessed value was to what some properties ended up actually selling for, it indicated, about 28% deviation from what it should have been according to their assessment sales study. There's a few more examples here. I know there's some others submitted in evidence beyond the Hinman and the Hohen study that Mr. Thayer testified to. But the Canning and Simmons study was actually prepared on behalf of the Canadian Wind Energy Association. That was their client. And they kept finding different ways to analyze that data, and each one of them kept showing that there was a numerical difference or percentage lower value. They ended up saying, though, that their results are not statistically significant, so that study has been I think kind of buried or pushed aside by the wind industry. They don't cite it anymore, and I understand why. The footnotes, I'm not going to read all of those, but that points out some more salient points or review comments that I've developed in reading through these studies. There's a couple that also aren't on there. The London School of Economics about a year ago produced a study that, well, I have not delved into that or had access to their data. It did find an 11% impact. It's an academic study and it's used regression. So if you like statistical analysis as opposed to actual value measurement, then that's as solid as any. The London School of Economics has a reputation that, as far as I know, is pretty good. Again, the studies that the Berkeley researchers and the professor and so forth have found find very low R-squared, very low explanatory power for their studies. And with a R-squared of 0.8, for example, that only explains 80% of the differences in the sale price. And to put that in real simple terms, if the value impact is 20%, or even 22 or 23%, that study could still conclude we didn't find any statistical proof that there's value impact. I'm not saying there is no value impact, it's just from a statistical standpoint, you can't prove that there's property value loss. I would suggest that instead of creating a big haystack so that you can find the needle, just go back to where the activity is and look at it very specifically, very focused, and compare the way, again, the Appraisal Institute and the accepted appraisal methodology for if you're actually trying to find whether or not there's value impacts, that methodology will reveal it, as opposed to getting buried in a large pooled database that there's no way you can find any impacts unless they're over 50% or something like that. I'd also point out that in the Berkeley, the more recent study in 2013, they have a statement in their report that for the purposes of this research, we will assume that a 3 to 4% is a maximum possible effect from the turbines. And where I come from, that's just a completely inappropriate assumption to start with. You start with the assumption of nothing other than you're going to really look for any evidence, if it exists, if there are impacts. And that study, again, has a very low explanatory power with an R-squared of 0.67, again, meaning that a 33% value impact, if it was there factually, it wouldn't be found statistically. That chart comes from that same study I was just referring to, and shows pre-announcement, post-announcement of pre-construction and pre-construction. And I don't pretend to understand exactly how they vetted all their sales. There's a lot in their reports that are not transparent. But what it did show is that the rate of increase was much lower for the properties within 1 mile that are demonstrated by the blue line. They start lower, they end up lower, and the difference in how much the property values went at greater distances versus within 1 mile is 32.3%, which I guess kind of ties together with the remark I just made about a 0.67 R-squared not being able to find 33% impact. The original Berkeley report that has been circulated worldwide, the devil's in the details. If you were to look it up yourself, what you would find, I believe it's on page 14 in the footnotes, starting around footnote 28, is that they specifically decided to exclude resales of property that showed, in one case a 36% value loss, and in another case an 80% value loss. And as I mentioned in the seminar that I presented to the Appraisal Institute, I kind of pointed that out as politely as I could, that it's not really an appropriate elimination or decision to not use those sales. It would have actually changed the results of their study, number one. Number two, these properties, again, were bought out by the wind developer at market value and then resold. I've looked into those sales. This is discovering this rather unusual exclusion from the study. And frankly, those are the properties, the buyout prices were right in line with what other market activity was showing, and the resale prices were big drops. I don't know for sure what their disclaimers were or easements, as in the case of the Canadian Hydro sales that Lansing refined. But it's their conclusions were just not supported by the empirical data analysis, and why they would eliminate those sales. They claimed it was because of related party transactions, which is not appropriate in an assessment sales ratio study. But they were, in fact, not related people, so I don't know how they got that. Some studies have been done by quasi-government bodies, in this case MPAC, which is the Municipal Property Assessment Corporation. It's actually a private company, but they do, on a contract basis, all the assessment work for the residential properties in Ontario. Ontario, much like Livingston County, has had many wind farm developments, very controversial, very hot political issue throughout Ontario, except in Toronto, the city. But many people were, some of them from Ontario were contacting me, how do we assess, how do we reduce our assessments to reflect the fact that our values are lower near the turbines. And I couldn't really help anybody in Ontario, other than to hire a local appraiser, attorney, whatever, but see what kind of forms you have to fill out. But ultimately, MPAC was asked by the Ontario government to prepare a study to see how close they were getting their assessments to the sale prices. And that's the real focus of their study, but there's a kind of a by the way in that study because that they didn't really focus on. But on careful review, I found it. And what you see in this table in their study is, first of all, there's a total of 41,424 sales used in that study. At the left side, you can see there's 279 sales that are located within a kilometer of any turbine. And the next set of bars, 989 sales at 1 kilometer to 3. The next set, over 3,000 sales at the 3 to 5 kilometer range. And let me point out that 5 kilometers is right about 3 miles, close enough. So the 3 bars on the left all show within 3 miles, where the bars on the right are all sales outside of 5 kilometers or 3 miles. The blue ones show what their assessed values are, and the green bar shows the actual time-adjusted sale prices. They had a very reliable basis for how much values have moved in general, and used that to time-adjust their sales. And what they showed was that their assessment sale ratios are actually very close to the time-adjusted sales ratios. In fact, they came within that 0.95 ASR standard. So they're very proud of this study, and rightly so, because they showed they were doing their job well. But then they left the reservation and said that this data does not show any value impact. And I think what they really should have said is this study does not show any lack of uniformity or equity of assessment, because what it really shows, price-wise, never mind their assessments, is that when you're less than 1 mile, there's a 25% difference from the control setback of over 5 miles, 26% at 1 to 3 miles, or kilometers rather, excuse me, and then 21% at 3 to 5 kilometers. The data is their data. The facts speak for themselves. There's a large number of data, so if one thinks there has to be a large number of sales in a study to be valid, I would suggest that this study is as valid as any and is much more transparent than others, because it actually shows what's going on at different distances. And again, I commend them for their using appropriate sales near for properties that are near turbines, because otherwise it wouldn't be reflected to actually reflect the value. So, sorry to the folks in Ontario. From what I see here, there is not a widespread basis for assessment appeals, but on a one-by-one basis, maybe there is. Well, with all that said, I guess I've come to a number of conclusions that, starting with the setbacks of less than 3 miles are inadequate to avoid significant loss of value or the impaired use and enjoyment of neighboring property. I'm not an acoustic expert, I'm not a doctor, I can't speak to those things as one of those experts, but I can tell you that I have talked to enough people that are describing the very things that a large number of very qualified acousticians, medical doctors, and so forth that are really independent have been finding that does happen. It doesn't happen to everybody, but it happens to a large enough number that it ends up translating and coming out in the wash in the real estate market and the sale prices. So if this project is approved as proposed, I believe the most proximate residential properties will experience a range of value impact from 25% at 2 to 3 miles to as much as 40% at some of the typical setback ranges when they're really trying to squeeze it in there as close as they can that the county ordinance otherwise allows for. Just because it complies with that, or perhaps even a modeled noise measurement, does not mean that there will not be a genuine or bona fide nuisance. The market keeps proving over and over again that there is. And ultimately, in my opinion, this project does not meet the requirements of the Livingston County zoning ordinance with respect to special use criteria that relate to the real estate value and compatibility, because there will be a substantial loss of property value. Briefly, the basis for those opinions are independent studies. They consistently find significant value diminution. The appraisal studies, which I believe are superior because they focus on paired sale data and resale studies of nearby data, as opposed to the Wind Industry Commission studies and related university studies that only use regression analysis, which often, particularly in the case of Berkeley, pools the data, and that really assures that no statistical significance will be found for value loss And just real briefly on that, if you have properties in Massachusetts that are average selling price of $350,000, then you go to Van Wert County, Ohio, where the average sale prices are $70,000. By the time they're developing and tweaking their regression study for what is a bathroom worth, it's going to be vary so widely between those two markets that it just really isn't reliable, and it carries down the line to their ultimate conclusions that are statistically measured in the weak R-squared findings. I would also add that non-appraisers, and while I don't mean this is a cheap shot, but they do not comply with USPAP, which is a set of regulations that applies to all licensed appraisers. And in fact, in Illinois, it also applies to anybody that's presenting a value opinion. And they don't comply with those on several levels. Again, I'm not here to take any cheap shots, so I won't enumerate that beyond my statement right now. You saw it as an exhibit, a paper called On Wind Farms and Rubber Rulers, written by Al Wilson. Al Wilson is an independent appraiser. He's retired now, or so I heard. But once upon a time, he was very much involved in developing the standards for measuring environmental value impacts, and he wrote and taught and lectured extensively on the subject for the Appraisal Institute and other professional associations. His resume is also an exhibit, so you can see for yourself. He kind of wrote the Bible, if you might say. And at the same time that Ben Owen, the author of the first Berkeley study, called me to request that I peer review that 2009 study, he apparently also called Mr. Wilson. And I have to admit, Mr. Wilson wrote a better review and critique of that study than I did. And what he found was many of the things that I'm talking about: the pooling of data, the lack of application of any standards, the lack of any indication in the Berkeley study of any testing or calibration of their model to see whether or not what they were saying actually proved out in the market. And then he also went into the lack of adherence to any mass appraisal standard. And as he cites it, the R-squared being under 0.9 is just really means that those studies, the original study that he reviewed had a very low explanatory power, and his basic conclusion was that, and very objective, he wasn't paid anything for this review. He's not on one side of the issue or the other. He makes it very clear in his paper. Frankly, I'm not either, even though I keep getting called by the folks that are against these projects. But Mr. Wilson's paper says that that the Berkeley study should not be relied on for any public policy purpose. And again, no cheap shot taken. It does not meet any objective, scientific, or appraisal profession or industry standards. It's kind of loosey-goosey and said what they wanted it to say. Statistical studies like Clarkson and Sunak also use regression analysis, but they don't pool the data, and they claim that their conclusions are statistically significant. But Clarkson and Sunak also find that there's fairly significant impact. In the case of the Clarkson study, within a tenth of a mile under one of their scenarios, it was the census tract analysis, it was up to 40%. Sunak, he just says basically within 2 kilometers, a 25% impact on the value of lots. So the Clarkson study, might be useful for understanding that the closer the distances, the more impact there's likely to be. And bottom line is, between mine and other studies, collectively, it's my opinion, and the findings are that the proximity impacts range from 25 to 40%. That's appraisalese and a whole lot of, hopefully you're still awake type stuff. But common sense is, there's a market resistance to buying a home in an overwhelming industrial setting. That doesn't mean you can't find a buyer. That just means there's market resistance. And also, the other side of the coin, there's a buyer and a seller of every property. The sellers are often under duress due to noise, health impacts, nuisance, and the invasion of the turbine impacts into their, that kind of defeats their peaceful use and enjoyment of the property. The discounts derived from the market adjacent to wind turbines are not unique in and of themselves. There's other duress conditions like foreclosure sales, liquidation, estate sales with very brief marketing periods, and other problem properties. It could be something with contamination that maybe doesn't look like a big financial problem, but it's just a big hassle to own a property like that. And people tend to steer clear of those, except for those that are the most risk-tolerant type of investors. In any project like this, there can be consideration of appropriate conditions. It's not my job to decide what those conditions are, but I would suggest to you that when you look at height, they often come in with the most latest state-of-the-art turbines that generate the most power, 400 to 500 feet. It says in my report what the exact height is that they're proposing here. But wind energy can be developed with much less height than 400 feet. Turbines work at 100 feet. So I don't believe it's exclusionary to put a height restriction on a turbine project. Hours of operation. Most businesses, especially industrial uses that emanate noise, have hours of operations limitations or must be conducted within completely enclosed buildings. Obviously, you can't put a turbine within an enclosed building and have it work at all, but the 24/7 operation is, I think, where most of the problems come from, frankly. Most of the nuisance and noise and health complaints are during normal sleep hours. If there was some relief from that, I would venture that the complaints would be much lower, and I don't mean meaningless relief, I mean let people get a good night's sleep, as you would with any other industrial use that's making a thumping noise or emanating some vibration or low frequency quality of noise. I'll leave the rest of that to the acousticians to explain, but that's how I look at it from a real estate perspective. Setbacks, that's the one single thing that can be done. And industry claims that standards of a quarter mile or less are, the industry standards. So, of course, they're just, working with the industry standards. But the experience really proves that these type of setbacks are too close. It can be measured via the property value diminution, the noise complaints, and the actual measurements post-construction often being far different than what was modeled. Carrie Schnellecker is a good example of that. The county up there, Mason County, Michigan, has in fact found Consumers Energy to get out of compliance with the zoning, even though all the assurances of the models that were made by the professional engineers, they swore that was not going to exceed this certain decibel level, and it turned out they were wrong. Flicker is something that is often presented as a rather nothing type of issue, but the people I've talked with that have experienced it claim quite the contrary. It's annoying as hell to sit at your breakfast table trying to have a cup of coffee in the morning and have a strobe light coming in through your window and where it looks like a jet is flying in 100 feet over your house over and over and over again. I don't know where this industry standard ever came from as far as being able to strobe light on somebody's property a certain number of hours per year. But I can tell you this, it requires a large enough setback, and that issue goes away, and there is no intrusion of the fenestration, light and air of the neighboring properties. Not to mention the aesthetics, and blade and ice throw, again, I'm not an expert on that, but from the setbacks that 1 times the height, 1.1 times the height, doesn't even come close to ensuring that there won't be a chunk of blade or ice thrown onto a roof or yard or playground equipment or whatever in a neighboring house. I've heard of projectiles being thrown as far as a half a mile. That's a lot more than 1.1 times the height. Ben Owen, you've heard me mention a couple times. Professor Thayer was here basically presenting work that Ben Owen had prepared, and then as a team, I guess they have expanded on since. But Ben Owen was interviewed by a town councilman in Cape Vincent, New York. His name is at the bottom of the slide. And you can actually find that recording online. But Mr. Schneider interviewed Mr. Owen and was asking him about property value guarantees. You know, I've read your study, so forth and so on. And I excerpted part of what that conversation said, but essentially what Ben Owen told Mr. Schneider is that when developers put our report forward and say, look, property values aren't affected, and that's not what we would say specifically, according to Owen. On the other hand, they have little ground to stand on if they say we won't guarantee that. And I think when the original, and I spoke with Mr. Owen as well, and he admitted to me that there might be some impacts up close, but their statistical studies really haven't found them. So they're not really focused on it. They're looking at the broader big picture of, let's convert everybody to wind energy and renewable energy and so forth. So there seems to be this implicit, it's okay to sacrifice, a handful of families or whatever to ground zero, whether it be their property values or their sleepless night. But Mr. Owen apparently didn't really understand what zoning codes are designed to do, and that's to protect the public health, safety, and welfare, and usually also the property values. So I think Mr. Owen might have keyed off me a little bit, because I had suggested to him when I peer reviewed his study that I think it would behoove him to put in a section on property value guarantees. It's not something that is poison. It's something that is done. It's been done with landfills. It's been done with quarries. It's been done with other wind turbine projects. Some of them are strong. Some of them are weak. Some of them are ineffective, especially if they're, they leave it to the developer to administer it. It's a fairly important issue for people living close by, so it really should have some oversight, in my opinion, that is not subject to a level of unfairness. It should really be on a level field. But in my opinion, the key elements that should be property value guaranteed includes leaving the property owners whole, regardless of whether they decide to sell or stay living in the project area. There shouldn't be any hurdles to be included. If somebody has a second home, I've seen it said that, well, their value should be guaranteed. They have another home in the city or whatever. Or this is just a vacation home, so why should we guarantee those values? And I would suggest that any investment is worth protecting for innocent landowner, including agricultural land, which are also not immune from devaluation. There should be a buyout provision in a property value guarantee that in the event the property is unmarketable after a typical or reasonable marketing period, as compared to areas where there are no turbines visible and no market impact. I already spoke about that I believe the administration of a value guarantee should be by an unbiased third party. Now that could include a retired judge, lawyer, professional appraiser, people who can understand the terms very clearly and that would have a professional desire to try to follow the requirements of the guarantee rather than ignore them. Sometimes they're written up as agreements between the developer and the property owner. I have found that really did not work out too well in DeKalb as far as power line as the way I heard it, kind of stonewalled people that filed claims. So really, in my opinion, should be an automatic coverage of property within 3 miles, just imposed as a condition, much like any other insurance coverage required for a project of this magnitude, scale, and intensity, and for general liability. Okay, that's great if a blade flies off and kills somebody or whatever, or does property damage. The insurance will cover that, but I believe it'd be appropriate to have insured and bonded as part of the value guarantee. It might also be advisable to have extend the range or the distance that would be covered by a property value guarantee if the low frequency noise or other noise nuisance is identified by an owner-occupant further outside of 3 miles, or or I should say, and measured by an independent acoustician and retained by the administrator of the property value guarantee. No hanky-panky. Let's find out the real answer. Is there actually low frequency noise impact in this house, or is somebody just complaining because they want to be bought out? So the bonding and insurance, I think, should cover 25% of the value as identified in the county assessment rolls, what the value of the properties are within 3 miles. As an insurance policy, it's not something I've seen done, but many things can be bonded, or the developer can certainly seek out a custom policy from Lloyd's of London or some collection of insurance carriers that cover high-risk issues. A lot of times things are not handled because most of these property owners, their life savings is tied up in their house. They can't litigate everything. I believe it would be a good idea to have the property guarantee panel and an agreement or condition that eliminates the need for property owners to file litigation that can bankrupt people. So the property value guarantee panel should be the final arbitration on these as part of the condition, and rather than let who has the deepest pockets prevail. Whatever the actual issue is, whatever the actual impacts are, that's what should be found, in my opinion, just as an objective, third-party, neutral appraiser. This is that transfer of easement and gross that I was mentioning from the Canadian hydro developers that they attach to contracts to sale those 5 properties that they bought out. And the arrow at the top kind of points to the fact that the easement grants them the right and privilege to permit heat, sound, vibration, shadow, flickering of light, noise, including gray noise, whatever that is, or any other adverse effect or combination thereof, resulting directly or indirectly from the operation of the wind turbine facilities. It's an acknowledgement by that developer that there are, in fact, these impacts that will go over these properties. That's why they bought them out. I am aware that there is a neighbor agreement that has been used, I don't know how many times, how many people signed on for it, but essentially it says the same thing. We'll pay you $1,200, you give us an easement, and while they don't use these terms, they're saying we're going to run a commercial wind farm operation. And basically, why pay for the easement if it's not the turbine's not going to be on that property, but it's just going to be these same impacts that don't stop at any participating property line. These impacts extend right on past onto the non-participating property owners of the land. And I would also point out with that second arrow is pointing out that the developer, the transferor, in other words, the person buying the house, granting the easement back, agrees that the operation of the wind turbine facilities located on leasehold lands may affect the living environment of the transferor and so on. So they're, again, very explicitly acknowledging that there are turbines which I don't think they're significantly different than any others. I've never heard of any magic turbines that don't create these same impacts. It's part of what happens with these projects. They acknowledge that they're trying to recover part of what they bought out properties for. In fact, they recover part of it, and that's not, the project's going to go ahead. That's not a bad solution for some people. Other people might not want to stay. Maybe to sell, maybe they can sell at market value, maybe not. But if they can't sell, I believe a buyout is an appropriate provision. Property value guarantee can provide for just that. That's all I have, other than a property value guarantee agreement that Mr. Lupians and I have consulted on to submit as an exhibit. With that, we'll to answer any questions.
Mr. Chairman, I have a couple follow-up, but is this a good time for Mike?
Yeah, why don't we take like 12 minutes? We've got 7:57, so why don't
You're not an MAI, correct?
That's correct, I'm not.
Okay, so an MAI is what?
Well, that stands for Member of the Appraisal Institute. It's one of a number of appraisal organizations, one of the oldest ones, and a well-respected organization.
And you've just never sat and tried to become an NAI?
I decided years ago that with state licensing that wasn't the end-all credential. It's not something that's required to appraise or testify to appraisal opinions.
And you've appraised, or you've testified in court before?
Many times, yes.
As an expert in appraisals?
That's correct.
And have you ever testified for a wind turbine company?
No, I have not, no.
I think it's around page 4 of your report talks about that there's 1,000 residential dwellings located within the project footprint. Is that a correct statement, or could you explain that?
Well, I think that's actually an error. I might have transposed the number. I know I was reading something in the Flickr study about there being 700 potential receptors and whittling it down, but as I sit here right now, I don't remember where I got that number of 1,000. I may have been thinking, 1,000 receptors for Flickr. That would certainly mean by the time you go 3 miles outside the project, there's that many more people and houses in the what I call the impact footprint.
But you're not sure if there's 1,000 in the project footprint, are you?
I'm not sure there is. No, that's correct.
If you could go to UCLC Exhibit 75. And you've seen these affidavits before and this information?
Yes, I have.
Okay, and for the record, these are affidavits of people, or the first 3, I think it is, affidavits are of direct testimony in the Wisconsin Public Service Commission hearing?
That's correct, yes.
And are they relate to people either abandoning their homes or having to sell them at lesser value? Is that something you're familiar with on a personal basis or have interviewed people about?
Well, these people, amongst others, I have spoken directly with Joseph Young. I've spoken directly with Ann Wirtz. What I read in this testimony is spot on with what they related to me as far as their experience with wind projects being built very near their homes in Wisconsin. It took Young quite a while to get bought out, but then, as I remember him telling me, and I also read this testimony, that now there's another project being proposed by where he ultimately relocated to. Am I here? Can you hear me okay?
Yeah.
Okay.
Yeah. That was a shock. These aren't the only people you've talked to who have had to abandon their homes over the years?
No, not even close. I could, from off the top of my head, Kerry Schindlecker, I mentioned earlier in my testimony, a gentleman by the name of Art Lundgren up by the project Wolf Island in the Northeast. A woman by the name of Sue Hobart in Falmouth, Massachusetts. That wasn't her property that sold, by the way. That's another property that last time I had any communication with contact from her, she still had not sold the property.
Yeah, I'm not asking for an exhaustive list, don't worry. You've appraised properties for mortgages, correct?
Yes, I have.
Okay. And when banks, in your experience, what do banks use to appraise a value or put a value on a property when providing a mortgage?
Well, they of course have the property appraised and they use comparable sales, they use a methodology very much like I'm describing, but specific to appraising a given house or shopping center, perhaps, with comparable sales and paired sale analysis to compensate for the differences between the comparable, or as I refer to them as the control sales, to measure the value of the subject property, or as in my study, the target sales that are being measured for any value impact from determinants.
Have you ever seen a bank use a regression study to determine the value of a house when they provide a loan?
None that I'm aware of. It was studies done, but they are not the basis for making mortgage loans on a property-to-property basis by any means.
You obviously have not sat through all these hearings, but we've heard a lot about peer review. Your independent appraisals are not actually peer reviewed, are they?
Well, usually no. Not in the sense that it's used academically, but in the case of the seminar I prepared for the Appraisal Institute, that did include, for example, my DeKalb and Lee County study and Falmouth Parrot Sale example and so on. And that was not just done like on some kind of internal academic basis, but the Appraisal Institute's Education Committee, in fact, peer reviewed my presentation before they authorized it for presentation of the membership. And as I believe I mentioned earlier, that presentation and sitting through that seminar was approved for continuing education credits for the Appraisal Institute members.
Okay. And you've talked a number of times about transparency. Would you consider the home study to be transparent?
I would have to say no, but there's a lot of numbers in it, but again, it doesn't identify a single property that has sold or that anybody could go look up on public record. It took a little bit of investigation work on my part to find out what the two properties that he mentioned in footnote on page 14 that the developer bought out and resold and what their addresses were and so forth. Because it was not, that was left out of the report. That was the closest he came to identifying any particular sales or identifying any particular property. So from an appraisal perspective, no, it does not lend itself to being defined as transparent or meeting any reporting requirements that are required under the USPAT or the Appraisal Institute's slightly different version of USPAT.
To your knowledge, has that data ever been publicly released? For the home study? Sorry.
No, to my knowledge, it is not. In fact, I did, as part of when he invited me to peer review it, I said, of course, you're going to provide the underlying data that your study is based on so that I can actually test your conclusions. And he informed me at that time that no, I'm not going to provide that data because all these records that supposedly came from public record, he claimed they were, he obtained it subject to confidentiality agreements, which, what can I say?
No further questions at this time. Thank you.
Thank you. Other members of the ZBA, do we have any questions at this point? Okay, yeah, we'll reserve the opportunity to go ahead and question you. All right. Any local government, school districts out there? Any questions? See any? Mr. Blazer, do you have any questions?
You'd fall out of your chair if I said no, wouldn't you? How are you, Mr. McCann? It's been a long time, hasn't it?
It has been a while, sir.
It's been about 10 years since the last time I cross-examined you.
I think that's right.
Just a couple of preliminary questions first. You mentioned Carrie Schnellbecker several times in your presentation, right?
I did, yes.
And you've met him face-to-face?
I have. I appraised his house before the project was built. Mayor's house, yes.
Mr. Schnellbecker is in his early 50s, right?
Sounds right. I didn't ask him his age.
And he's an industrial design engineer. You aware of that?
Rings a bell. Again, I'm not a personal friend of his or otherwise.
But that sounds right to you, doesn't it?
I'm trying to remember the name of his company because it was on his email.
Well, that's okay. You've met his wife as well, haven't you?
I have, yes.
And she's in her mid-40s?
I really don't recall.
She's a teacher?
That does ring a bell.
We should probably not talk about her age publicly, should we? Okay.
Suit yourself.
And just really quickly, this UCLC Exhibit 75, this material from the Highland Wind application, were you involved in that hearing process?
The Highland Wind application?
Right. It says application of Highland Wind Farm LLC for for a certificate of public convenience and necessity to construct a 102.5 megawatt wind electric generation facility.
Was that the one in Mason County? Because I don't know if I had that name.
No, this is Mr. Young's material, and I guess there's some more stuff. It's UCLC Exhibit 75, the one Mr. Lucahan's just asked you about a few minutes ago.
I'm sorry, I'm not following Mr. Blazer. It's they took it too fast or something. Oh, okay. I think that became known as the Forward Wind Energy Project. I didn't know it by that name, Highland.
Whatever name you know it by, were you involved in it?
No, it was not.
Oh, so you don't know that the Wisconsin Public Service Commission granted the siting permit for this project?
Oh, the Wisconsin Public Service Commission has approved many siting applications. So.
I'm asking you about this one. Do you know that they granted this one?
I believe it was, yes, because the turbines were built, so that stands to reason, yes.
Mr. Lucahan's asked you some questions about the Appraisal Institute. Who's William McCann?
That would be my father, yes.
And your father is an MAI, a member of the Appraisal Institute, right?
Yes, he still holds that designation.
He has been for many, many years, right?
Yes.
And would you agree with me that the Appraisal Institute is one of the more noteworthy organizations to belong to in the appraisal industry?
It certainly is one. It's not without its problems, but it is a overall a well-respected organization. Yes.
And we've established this, I think. You don't hold the MAI designation like Mr. Burroughs here does, correct?
Well, I don't know, like anyone else does that has it.
Okay. And you know that the MAI designation is held by appraisers who are experienced in the valuation and evaluation of commercial, industrial, residential, and other types of properties, and advise clients on real estate investment decisions, right?
Well, that can apply to some MAIs, I don't think all of them, and that same statement can apply to members of many other organizations or state licensed appraisers such as myself.
I'm showing you what's marked as Pleasant Ridge Exhibit 175. That's a summary published by the Appraisal Institute of the requirements someone has to comply with to achieve the MAI designation. And you haven't achieved those requirements, correct?
Well, I certainly completed the use path requirements. I did not complete the college degree requirement. I've completed a number of their courses. And one that's not on here, but I was certainly invited by them to prepare that seminar.
That wasn't my question, sir.
Projects.
You also
Qualifications.
don't hold the Appraisal Institute's SRA designation, correct?
That's correct.
And the SRA designation is held by appraisers who are experienced in the analysis and valuation of residential real property, right?
Well, presumably so, along with many other residential appraisers who don't hold the SRA designation.
And then I'll hand you what's been marked as Pleasant Ridge Exhibit 202. And that's a summary from the Appraisal Institute of their requirements to achieve the SRA designation.
And you haven't completed those requirements either, is that correct?
That's correct, nor have I completed any requirements for a medical doctor degree.
Except you're not purporting to be a doctor, you're purporting to be an appraiser. So, move to strike.
If he wants to make a statement, he can testify. If he wants to ask questions, he should ask questions. I'll show you what's been marked as Pleasant. I have an objection on, but I'd like to rule upon it. I'll move to strike the medical doctor since that was unresponsive.
That is correct in both instances. I guess they both should be struck. McCann, if you could just refrain from interjecting and just answer the question that he asked. Don't move our evening along.
I'll do my best, Mr. Chairman.
Thank you.
I handed you what's been marked as Pleasant Ridge Exhibit 176, which is a list of all of the Appraisal Institute designations. And you don't hold any of those, is that correct?
No, I do not.
Okay. Now, the opinion you're giving here is about the potential impacts on property values from the proposed wind farm, correct?
Well, I would take it a step further. I say it's the probable impacts, not just the potential.
Well, whatever it is that you're doing, it's known in the appraisal industry as determining the potential impact from a detrimental condition, correct?
We're measuring a detrimental impact on the value, yes.
And you've testified about that sort of thing before, right?
Many times, yes.
I'll hand you what's in the record as Pleasant Ridge Exhibit 39, which is Professor Thayer's presentation in this matter. And I've tabbed the 8th page there for you, if you could turn to that for me, please. And that's just a graphic representation, as you can see, about how proximity to and views of environmental disamenities can impact property values. You see that?
Yes, I do.
And this is generally speaking what you're talking about here, right?
Well, I talked more specifically, but this does give some examples as he sees fit to present, yes.
So for example, from Professor Thayer's presentation, a Superfund site, a landfill, or a transfer station would be a disamenity or have a negative impact on value, right?
Well, that's how he's describing it, yes.
Or create what you called a stigma, I think, earlier, right?
Well, it can and sometimes does have those kind of impacts, certainly.
And then on the flip side, on the other side of the equation, amenities, positive amenities, like green space or ocean views, can have a positive impact on value, right?
That's correct. I used a slide from the 2009 study that illustrated exactly that point numerically.
Honestly, if you just answer my questions, we'll go through this a lot faster.
Okay.
You know what, he's an expert. He has the opportunity to explain his answers, especially since I don't have an opportunity to redirect.
Some other positive amenities would be, for example, lake views could be a positive amenity.
Generally speaking, yes, sir.
Municipal sewer.
Excuse me?
Municipal sewer.
A view of it?
No, having municipal sewer versus not having municipal sewer. That could be a positive amenity.
Well, that's not related to views, but...
I'm not talking about views, I'm talking about positive amenities.
Quite know my answer, Council.
All right, go ahead.
Please let me answer. It depends on the market area. If you're in an urban area, certainly municipal sewer and water is deemed by the market as an amenity that adds value, where if you have a little pocket that has not been tapped, hooked into sewer and water, those properties, at least in my experience, have experienced longer marketing times. When you get to a rural area or a rural residential area such as we have here in Livingston County, no, I don't believe sewer and water has a measurable impact, that follows the Dr. Thayer chart.
How about wooded or high-end subdivision sites? Could those be positive amenities?
They certainly can be, yes.
Okay. Now, regardless of your lack of relationship with the Appraisal Institute, I think you've confirmed there are some rules that you are governed by, right?
That's correct.
And that is the Uniform Standards of Professional Appraisal Practice, or USPAP?
That's correct.
Okay. You're familiar with the USPAP, right?
I've been qualified as an expert on it in the Cook County Circuit Court, yes, sir.
So then, this book I'm holding up, that's the current version of USPAP?
2014, 2015, yes, sir.
Okay. And then, do you have your report there?
I do.
Okay. If you could turn to page 56 of your report, please. You got it?
I do.
The fifth full paragraph, it says, a signatory of the appraisal report is licensed by the state of Illinois as a certified general real estate appraiser. That's you, right?
That's correct.
Okay. And in fact, you have to be familiar with USPAP as part of your Illinois state license requirements, right?
That's right, and take the course at every license renewal period. That's correct.
And just so we all understand what it is, I'm just going to give you a general definition. Tell me if you agree with it. USPAP is a body of guidelines that include appraisal standards for development and reporting of appraisal or consulting assignments. Does that sound right?
Yes, it goes much further than that, but that's a good, accurate, partial summary.
And it also includes ethical requirements?
Yes.
And as a matter of fact, the USPAP is incorporated into the state appraiser licensing statute. Right?
Yeah, the licensing act of 2002, yes, sir. Anybody presenting value opinions to the public is actually bound by USPAP.
And then showing you what's been marked as Pleasant Ridge Exhibits 207 and 208.
That's the Illinois appraisal statute incorporating use map and the regulation that addresses it, correct?
Well, this is a summary, and I gotta admit, I'm more familiar with reading a much lengthier document.
Well, just for the record, 207 is 225 ILCS 458-1010, standards of practice. All persons licensed under this act must comply with standards of professional appraisal practice adopted by the department. And the department, you know, is the Department of Professional Regulation, right?
Correct.
Okay.
As I've done.
The department must adopt, as part of its rules, the Uniform Standards of Professional Appraisal Practice, as published from time to time by the Appraisal Standards Board of the Appraisal Foundation. Correct?
Correct.
Okay. And then if you look at Exhibit 208, that's a section from the Illinois Administrative Code pursuant to which the use map is in fact adopted. Correct?
I haven't memorized it from this particular exhibit. I certainly read it in the statute online. And,
Subparagraph B, all real estate appraisers licensed under this act shall practice in accordance with use map, except where the standards are contrary to Illinois law or public policy. Do you see that?
yes, it's referring to jurisdictional exceptions that are often invoked by appraisers doing condemnation appraisals.
Handing you what's been marked with Pleasant Ridge Exhibit 178. I'll represent to you, sir, that these are some excerpts from the 2014-2015 use
Can I get my
map.
glasses, Mr. Blazer?
Plus,
Fine, Mr. McKinley.
if I may, I would like to hand out the entire use map instead of just a section of it, so the client, so Mr. McCann can actually review the entire use map if necessary. Since it's available, I would ask that that be placed into evidence, and I have copies for everyone, other than just excerpts.
Well, if Mr. Lipkehans wants to do that at some point in this case, he can. For my purposes, there are specific sections that I tend to ask questions about, and he can do whatever he wants later, but this is my cross-examination, not his. And I object to him introducing any additional evidence at this point during my cross-examination.
I'm not introducing any evidence. I'm introducing the full document, which I think, one, the witness has the right to have in front of him, and two, I think that this board would want the full document, not just 10 pages out of what is an 80-page document.
Okay, why don't we do this? Mr. McCann, you have identified the 2014 book that Mr. Blazer has in hand.
That's correct.
Okay. Mr. Blazer, can you allow him to have that book while you ask him questions?
Sure.
Okay.
I have it right here. I'd rather give him mine rather than yours.
You know what?
Okay. We'll accept these 10 pages in the effort of environmental stewardship.
Okay. Let's look at my excerpt. If you could pull that one up, please. It's Exhibit 178. Most of these, I think you're probably familiar with. You are aware that an appraiser must not perform an assignment with bias, right?
That's correct.
And you know that under the Code of Ethics of USPAD, an appraiser must not advocate the cause or interest of any party or issue.
That is correct.
You also know that an appraiser must not accept an assignment that includes the reporting of predetermined opinions and conclusions, correct?
That is correct.
And you're also aware that an appraiser must not communicate assignment results with the intent to mislead or to defraud, correct?
Absolutely.
An appraiser must not use or communicate a report that is known by the appraiser to be misleading or fraudulent, correct?
That's what it says, yes, sir.
An appraiser must not accept an assignment or have a compensation arrangement for an assignment that is contingent on the reporting of a predetermined result, correct?
That's also correct.
And finally, an appraiser must not accept an assignment or have a compensation arrangement for an assignment that is contingent on a direction in assignment results that favors the cause of the client, correct?
It says all that, yes, sir, Mr. Blazer.
Do you tailor your testimony to suit what your clients want?
I tailor my testimony to follow the facts and where they lead me. My opinions are my own, they're not my clients'. I don't report predetermined results. In fact, before I was retained on this, I said, given the fact that there are existing wind energy projects in Livingston County and adjacent to Livingston County, I don't think I can accept this assignment unless I study the values specifically in this location. And as the market often proves to be, it showed the same results that it consistently shows in other locations.
So thinking about those use map requirements that I just read to you, you're saying that you haven't violated any of those provisions in this proceeding?
I'm affirmatively stating I have not violated a single comma of use map, much less any of the rules.
Let's talk about some of your prior experience doing the sort of thing that you're doing here that's determining the impact of detrimental conditions.
Sure.
You've done it not just in the wind farm
That's correct.
context, correct?
That's correct.
You've done a fair amount of work, of this sort of work, detrimental condition work, for garbage companies, is that right?
It's been a number of years, but I have done some studies in the past, studied property values around existing landfills, where the properties mostly had been built up, kind of encroached into areas where landfills have been developed. Yes, sir, I've done that kind of work.
And you've testified generally that garbage transfer stations will not have a negative impact on surrounding property values, correct?
Well, no. What I've said is when they're sited properly, for example, in an industrial park, that is an appropriate place for an industrial use. I've also said that in the middle of a residential neighborhood is an absolutely inappropriate location for an industrial use, such as a transfer station, or for that matter, wind turbine project.
So is it still your opinion that a facility that's overrun by rats will not have a negative impact on surrounding property values?
Counsel, that completely misrepresents anything I've ever said, because I never even came close to making a statement like you just made. That's just ridiculous. I'm sorry.
These aren't exhibits, no, they're transcripts.
Counsel, it's page 431 of Exhibit 179. I mentioned when we first started talking here that the last time I cross-examined you was in a waste transfer station proceeding. You remember that?
I do.
And you were representing a company called Flood Brothers Disposal?
No, I was not representing
So you were testifying for them?
I was working for their legal counsel, much as Mr. Bruce is working for you tonight, but I wasn't representing anybody other than my opinions based on the research I'd done.
So I misspoke, I apologize.
Yes.
You testified on behalf of Flood Brothers Disposal, correct?
That's a fair statement, yes, sir.
Page 431, starting at line 17. Question. Would the presence of rats resulting from the presence of a transfer station have a negative impact on either the character of the surrounding area or the property values? Answer. I have not seen any occasion where any concern about rats has caused any diminution in property values. Remember that?
No, objection. First of all, I'd like him to read the rest of the answer to that particular question, and then I'm going to object to the question. But the full answer should be read.
Okay, before we can talk about what we're talking about, we need to decide what this exhibit is, and I don't think we have it. What number is it?
Well, it's a transcript. I haven't introduced it into evidence yet, Mr. Cornell. I can certainly give it to you if you want it.
Okay. Mr. McCann, did you in fact concur that you testified at this particular?
We have no objection to the fact that he testified at this hearing. I think he's going to admit that that is a partial answer to his question. All I want is the entire answer read into the record so it is put in context. I don't have the right to redirect, so at the very least, I think the entire answer should be read in, not a partial answer.
Okay. Ask and you shall receive. Blazer, thank you for providing the exhibit. Now, as Mr. Lucan's, we do deserve to get the entire question and the entire answer read into the record.
I need to go back.
Mr. Lucans, can you tell me what page?
It's page 431. It starts on line 17, and it goes on to page 432, and the end of the answer ends on line 3.
Okay. So, Mr. Blazer, I'll ask that you read the entirety.
Question, would the presence of rats resulting from the presence of a transfer station have a negative impact on either the character of the surrounding area or the property values? I have not seen, answer from Mr. McCann. I have not seen any occasion where any concern about rats has caused any diminution in property values. I honestly have not seen a rat when I've at the various transfer stations I've been to, so I think that really falls under the category of, housekeeping and rodent control, and, making sure that no problem develops.
Okay, now I'm going to object on the basis that that is not impeachment. That is not inconsistent at all with his answer. The question was not this question. It was a completely different question that Mr. Blazer raised about rats running all over the place and, not causing a diminution of value. This is not impeachment. If he wants to enter this transcript, I don't know that I care. But let's not talk about it as somehow being impeachment, because it's clearly not that.
I'll repeat the question to which he answered no. The question I asked him was, is it still your opinion that a facility that is overrun by rats would not have a negative impact on surrounding property values?
Okay, and
Here is the question I asked him 10 years ago, Exhibit 170.
yeah, and so where
With the presence of
I
rats.
think that's already in the record, so I want to make my objection to it, which is overrun by
Okay, you guys
rats.
stop. Please just stop. We're getting nowhere. Our poor court reporter, I feel sorry for you tonight. Okay.
Can we go on now, Mr. Cornell?
I'm not even sure. What do we have? We have an objection by Mr. We have an objection by Mr. Lucan's that he's changed the scope of the question. Is that an accurate report of what's happening?
Yes, if I may explain. Impeachment, as Mr. Blakeman will tell you, is someone answering the same question a different way than they previously answered. The question was not phrased that his answer was in any way inconsistent between the two questions. The first question was a very broad, overbroad question that talked about diminution, overrun by a facility overrun by rats. The question we're now asking him about has nothing to do with the facility being overrun by rats, as is very clear in the answer.
I understand Mr. Lucan's concern now. If I may proceed, I think I can clear it up. You also testified, Mr. McCann, on behalf of another waste company called Strom, S-T-R-O-M. Do you remember that? That one was in Maywood.
Rings a bell, yes.
That's Exhibit 180, Mr. Lucan's. Page 184, starting at line 18. Question. So if this facility met all the requirements except that they were overrun by rats, and rats ran throughout the entire neighborhood, in your view, they wouldn't have a negative impact on the surrounding community? Answer. I think it would scare the hell out of them, but I don't know it would necessarily cause a loss of property values. No one would want to see rats running anywhere. You remember that one?
Not specifically, but I don't argue that I was identifying that, yes, rats could be a hell of hell of an impact, but I have not seen it in property values. I don't argue with that question or answer.
And both of those situations
When you were working for the waste company, correct?
Yes, and there's often some very far-fetched questions, such as the being overrun by rats type of question that really deviate quite a bit from what the basis of my opinions are. And while I have not worked in any of those facilities in quite some time, Mr. Glazer, I can tell you that part of the underlying assumption in any of my reports on those type of facilities is that they would comply with all the environmental protection regulations, including such things as vector control, which, as you know, includes rats, it includes birds, it includes things of that nature. So what I don't assume in those studies, or never did, is that there would be such a situation where there are rats being overrunning a neighborhood. But if you're familiar with Maywood, it's...
I think we're going well beyond the answer to the question, Mr. Brown.
Okay,
I'll move on. Let's talk about wind farms and leave rats alone.
Sure.
You've been a witness for opponents of a number of wind proceedings, correct?
Yes, sir, I have.
And is it your position that you're not biased against the wind industry?
It's not just my position, it's my absolute statement. I don't have a horse in the race one way or the other. I'm not an investor in properties near turbines or in any wind energy company. What I do counsel is I go where the facts lead me, and that has happened to generate...
Mr. Cornell, again, if you could instruct the witness just to answer the question, we might get done tonight.
Counsel, you're speaking to bias.
Excuse me. Mr. Cornell.
I think he has the opportunity to explain his answer, and I'd ask him to give it.
Yeah, you can elaborate a little bit on these. You are an expert witness. We'll allow you to elaborate a little bit. Just consider your answer before you start.
Yes, sir.
All right. If you could go to page 60 of your report, and that's the summary of your testimony in wind projects.
It's in this file somewhere. Well, this isn't the official exhibit, it's my copy.
That's whichever one. I assume the pages are the same.
What did you say, page 60?
Yeah, the list of the cases where you testified.
Yes.
Right. One of the ones you identify is 2013 in Tipton County, Indiana.
Yes.
And that was the BZA, which was their version of Livingston's ZBA, right?
Basically, yes, except in Tipton County, Indiana, the Board of Zoning Appeals has the final authority as opposed to being a recommending body to the county board. But it essentially serves the same function, it's just the final decider.
And you were testifying under oath there too, right?
Yes, I was.
I'll show you what I've marked as Pleasant Ridge 186.
That's an excerpt, but you remember the cover. That's a portion of the presentation you gave in that proceeding, right?
Yes, I was well aware of the kind of comments that Mr. Thayer and others had made about me, because I've heard them through the grapevine, if you will. So I called.
All right, I haven't asked you a question yet. I just asked you to get all this out here. Mr. McCann,
I can't write this.
again, I apologize. Mr. Cornell, again, if you would direct him to answer the question. I didn't ask him anything about the document yet. I just asked him to tell me if he recognizes it.
Yes, I do.
Thank you.
And looking at the slide number 4 there, the one that starts anti-wind activist or lobbyist, question mark.
That's correct.
Okay. You said the things on that slide because you have, in fact, been accused of being an anti-wind activist or lobbyist, right?
By the wind industry spokesman, yes.
And the last bullet on that page is characterization, claims, or allegations to the contrary are false, right?
That is correct, that's right.
And that's the point we're making. The point is, you're saying you're not an anti-wind activist or lobbyist, right?
I'm a professional the State of Fraser Council.
Again, if you could just answer the question, Mr.
I am answering the question, Counselor.
Mr. Cornell, again,
No,
the question.
excuse me. First of all, it's impossible for her. If he wants to move to strike afterwards, that's fine, and we can deal with it at the time. But over-talking the witness makes it impossible for June. It makes it impossible for us to have a record of any kind. And I would ask that he let the witness finish the answer.
All right, the witness needs to answer the question. If I feel that he's expounding too much, I'll stop.
I appreciate it.
Okay, Mr. Blazer, don't stop. Mr. Lucas, don't stop. I'll stop.
And as a matter of fact, in the context of you testifying in proceedings like this, if you were in fact an anti-wind activist or lobbyist, that would be a violation of USPAP, right?
If your hypothetical and frankly rather insulting insinuation were true, then yes, that would be a violation of USPAP.
Because it would constitute improper bias, right?
If what you said was true, then yes, that would be true.
And your statement that you're an independent appraiser bound by USPAP in that exhibit, lobbying efforts against the wind industry would certainly be contrary to that statement, right?
If I registered as a lobbyist in any manner, as the wind industry has their lobbyists, then certainly I could see where that might be viewed as something that was a violation of USPAP. But I am not a lobbyist. I'm a professional, independent appraiser, beholden to no one.
When you testified in this county back, I think it was 2010, with respect to the Deer Run project, who were you working for then?
I believe my client was a doctor. I don't recall her name.
Tannehill?
I'm sorry?
Tannehill?
I don't remember.
Who was the attorney?
Well, there were two attorneys, and the attorney that took most of my direct is a gentleman, I don't remember his name.
And the other attorney was Carolyn Gordon?
Yes, Carolyn Gordon was an attorney also working for objectors.
I'll show you what's marked as Pleasant Ridge 188.
Have you ever seen that document before? And just to summarize it for you, this is a letter where Ms. Gerwin, on behalf of Illinois Wind Watch, was lobbying Congress in opposition to extending the production tax credit.
I'll object to what she was doing.
I'm just-
What it is, the word lobbying, whatever she may have been doing, it's not for him to testify. The document speaks for itself.
I'm just asking if you've ever seen that letter before.
All right, Mr.
It's
Blazer.
that question,
Mr.
not
Blazer.
the one that's implying something else.
Regardless of, it appears that he was employed by Ms. Gerwin to testify. What Ms. Gerwin does outside, she can hire an individual, much like you hired individuals to testify. So, unless you're going somewhere with this,
I'm going somewhere with it.
all right, why don't we move it along? Okay.
Right now, I'm just asking, I still need an answer to the question, has he ever seen this letter before?
Well, I've been looking at it while we've been going back and forth here, and I can't say I've specifically seen it. I'm reading some of the captions, some of the issues and words and whatnot, and phrases, which I have not read the entire thing. Looks consistent and familiar with many things I've read, some put out by community groups, some put out by the wind industry or their lobbyists. But I can't specifically say under oath that I have seen this document.
But it looks like documents you've seen put out by lobbyists for the anti-wind industry, right?
Well, that's not what I said. I said community groups. I don't really know of any anti-wind lobbyists per se. Or lobbyists require deep pockets like the wind industry is.
I'll show you what I've marked as.
Just to clarify for the record, the witness has not identified this document as something that he has seen.
That's correct.
Okay.
I acknowledge that. 187.
Is Pleasant Ridge 187 something you've seen before?
Yes, it is.
That's a letter you wrote, right?
It is.
To Congress?
It is.
What's
I wrote it as a real estate appraiser.
What's the date of your Tipton County, Indiana presentation?
I don't recall specifically.
You got it right there. It's on the front cover.
March 20, 2013.
And what's the date of that letter you wrote?
April 15th, 2013.
And when you sent that letter to Congress, were you working for someone or were you espousing your own opinions?
Well, I think it would be fair to say I was espousing my own opinions. I was not working for anybody. Again, I was not working as a lobbyist.
In that letter, let's talk about these impacts that you say to Congress have affected a large percentage of people living within approximately 2 miles of wind turbines.
That's what my findings have been, yes, sir.
Do you agree that anecdotal reports do not rise to the level of empirical evidence?
You'd have to define the terms a little better. There's one factual anecdote is better than a truckload of statistics that are meaningless to the issue.
Do you agree that professional opinions must be made based on objective analysis of empirical data and not on anecdotal reports?
I agree that anything I write is based on the evidence that I've reviewed from the market and from reports of people in the market, and that's all I did.
Go back to Exhibit 186, that's your Tipton County presentation. That's slide 4 again. One of the things you say on that slide is professional opinions are based on objective analysis of empirical data. Do you see that?
I believe I said the same thing in 187 too, yes.
Okay. And when you say objective analysis of empirical data, you mean that all empirical data should be obtained and analyzed without bias, right?
Well, that's correct.
Okay. Do you agree that the strength of any research like this depends on the ability to gather and analyze empirical data in the most unbiased and controlled fashion possible?
Would you rephrase the question or repeat the question?
Sure. All I have to do is read it again. Do you agree that the strength of any research like this that you're doing depends on the ability to gather and analyze empirical data in the most unbiased and controlled fashion possible?
Yes, sir, as I've done.
And you don't base your opinions on anecdotal information like what someone might say at the dinner table or what might have been said to a newspaper reporter, right?
What I do is what's required under the appraisal profession standards. To answer your question, counsel, I'll keep it brief if you'll let me answer.
Mr. Cornell?
He is answering the question.
Right.
If you asked about dinner table, you're going to get PAP, PAP, whatever.
Mr. Glazer, the Appraisal Institute, USPAP, requires verification of information. This includes personal interviews with people. So what you describe as anecdotal, I describe as extra due diligence in confirming what happens in the market area rather than making unsupported assumptions based on what is sometimes merely occurred by PR marketing experts.
Mr. McCann, you testified in a wind proceeding in Lee County just a couple of years ago, right?
That's right.
The applicant in that case was a company called Mainstream Renewables. You remember that?
That's right.
You remember the county board approved that application, right?
I'm often not included in all the details, but yes, that is ring a bell.
All right, this is, council, page 1783, starting at line 20. While I understand, this is the question, while I understand the general description of what a detrimental condition is there a methodology for quantifying and determining whether or not a condition actually is detrimental to a neighboring property? Answer. Yes, there are empirical methods for extracting out what the market is actually saying in terms of dollars and cents. How are they actually treating this when it comes to the buy-sell decision, which can be somewhat different than what they might say, at the dinner table or, to a newspaper reporter. But while I listen to what people have to say, pro and con, I base my opinions on the empirical information. Do you remember that?
I don't specifically remember it, but it sounds like a conversation that I very well might have, yes.
And it would also be inappropriate to base an opinion regarding the impact of a detrimental condition solely on interviews of other appraisers and tax assessors, right?
I didn't hear you very well. Well, the mic went just an inch maybe.
Sure. Put it away.
Well, it's kind of a little bit of tonight.
Let me try it this way.
All right.
And it would also be inappropriate to base an opinion regarding the impact of a detrimental condition solely on interviews of other appraisers and tax assessors. Is that right?
I believe that is correct, yes.
Surveys are not a valuation technique, correct?
Surveys are sometimes used when somebody hasn't done the actual empirical research. I've seen so-called impact studies done, for example, where all they did was interview an assessor. What does the assessor think the impact has been? In fact, I did such an interview with Lee County assessor years ago, but then I went on to actually look at the empirical data.
That same transcript from Lee County, our Exhibit 206, Council, starting at page 1792, line 10. Question. And is it appropriate for an appraiser to base an opinion on values solely on interviews of other appraisers and tax assessors? Answer. In my opinion, no. The texts I've read actually state the contrary, including the Randall Bell detrimental conditions test, appraisal journal articles, and so forth. Surveys are only suggested as appropriate to use when there is an absolute absence of any data, any empirical data, and then with extreme limitations. But surveys, just generally speaking, no. They are not a valuation technique.
Objection, improper impeachment. There's nothing in there that's inconsistent with what he just said. That's not impeachment.
That is correct. Everything that you previously stated is pretty much verbatim of the chart of this Randall Bell. He did say no to the interviews solely, or value solely on interviews.
Well, my question, Mr. Cornell, was surveys are not a valuation technique, is that right? And
That wasn't your last question.
that one,
You want to have her read it back?
Yeah.
Wait, it was surveys, and he answered no.
actually, he didn't answer no, but we can move on, Mr. Cornell. All right. Obviously, you are familiar with Randall Bell, correct?
Not personally, but his work, yes.
All right. Mr. Bell is an MAI also?
I believe he is.
All right.
And
You're familiar with, actually, I think you quoted it in your presentation, his book, Real Estate Damages, an Analysis of Detrimental Conditions.
Yep.
And that's very much of an authoritative treatise on the issue of detrimental conditions in the appraisal industry, right?
It certainly is one good set of concepts, methodologies, and examples, but it is not an all-encompassing compendium of that.
My question, Mr. McCann, was, it is very much of an authoritative treatise on the issue, is it not?
Objection, asked and answered.
You didn't answer it.
Just go ahead and answer again.
It is one amongst many authoritative treatises.
And you're also familiar with his subsequent book, Real Estate Damages, Applied Economics and Detrimental Conditions, right? You've seen this one before also, haven't you?
I'm not sure I have.
aware that Mr. Maroos was one of the reviewers on this authoritative treatise?
No, I was aware that he participated in the 12th or 13th edition, I forget, of Appraisal Real Estate as one of the reviewers.
Well, in the book that you are familiar with, Mr. Bell identifies the accepted methodologies for appraisers to determine whether or not a condition is detrimental to a neighboring use, right?
He speaks about many things to that point, but there's more than one reference in that book. So when you ask the question, I guess I have to say yes, many.
He also specifies the valuation techniques or procedures for measuring any impact on value of those detrimental conditions, right?
He cites many of the processes that he's developed and that have been generally accepted and that have been tested in courts and that are used in the appraisal profession, yes.
Have you ever seen this book before, Wind Turbine Syndrome by Newman Pierpont?
I've seen the cover, I've never read it.
Mr. Glazer,
Yes.
do you have questions regarding his report and his assessment? If you do, I totally want that. But
All right, that's fine.
wind turbine syndrome, he's not a doctor.
I'm skipping quite a bit here, Mr. Cornell, but there is something I have to ask him about before we get to his report. I hope you'll give me a little bit of leeway. Okay?
All right.
One of the folks that you reference in your report is an individual named Mr. Lansink, L-A-N-S-I-N-K, correct?
Yes, sir, Ben Lansing, member of the Appraisal Institute of Canada.
And you actually worked with him on a project in Canada, right?
Yes, we did submit some written testimony in an environmental review tribunal hearing as a joint work product, yes, sir.
And your client in that matter was a Ms. Esther Reitman, W-R-I-G-H-T-M-A-N?
Well, client would be I guess the appropriate term, but it was in fact a pro bono matter.
189.
Pleasant Ridge Exhibit 189 is in fact the material that you and Mr. Lansing submitted to the Ontario Environmental Review Tribunal, correct?
It's certainly part of it. I believe there were a number of other studies submitted to the ERT.
Well, what I'm asking about is the report that you're holding in your hand. You do recognize that report, right?
Yes.
Okay. And you and Mr. Lansing obviously acknowledge that you're not health experts, correct?
That is correct.
And nor are you experts at determining if a person's health is affected by neighboring wind turbines, is that correct?
Not from a medical perspective, no, sir.
Okay. And if you could go to page 2 of that report at the top. You and Mr. Lansing here say that this report that you have in front of you is not a land value report, right?
It is not an appraisal pertaining to the value of real estate.
Well, you specifically say it's not a land value report, right?
Oh, the title. Yes, that particular caption has a hyphen that says a human species habitat witness statement.
Right.
Is what it is.
And then below that you say the reader is advised that this report is not a market value estimate, it is not an appraisal pertaining to the value of real estate, and it is not a consulting report. Did I read that correctly?
I believe you did.
So this report, according to you, was not the type of report that you submitted in this case?
It is not, that's correct.
Okay. Let's look at some of what you said. Still on page 2, fourth full paragraph. The paragraph where you're talking about the common denominator, do you see that one?
Not sure. Okay.
You got it?
All right.
And you've made statements like this about the correlation between reported health impacts and impacts on real estate values in your report in this manner, correct?
I'm sorry, I was reading that and listened as well as I
Could you
should.
read that back to me, Jim, please?
And you've made statements like this about the correlation between reported health impacts and impacts of real estate values in your report in this matter, correct?
What I was referring to was the correlation of proximity of turbines and the reported health impacts, not my determination that there are.
Right. But you're making the same types of statements, if you need to see it, it's on pages 20 and 21 of your report in this matter.
Right. There are certainly many reports of health impacts, and there are certainly many reports of noise impacts, and whether you're talking about it from a property value standpoint or the surrounding environment, which in Canada they don't have any property value standard under the Clean Energy Act. But what I was asked to do was address, along with Ben Lansing, from a real estate perspective of human habitat, because they are concerned about turtles and birds, but not human beings or their homes.
I see. Well, for example, if you go to page 18 of that human habitat report, you've got a summary of your testimony on wind energy projects, right?
Yes.
That's pretty much the same one you submitted here.
Might be another one or two or so added on there since.
Okay.
Mr. Laser, not to interrupt, but
I'm moving on.
relevance of this report
Sure.
to specific Livingston County wind farm.
Well, before we get to specific Livingston County wind farm, Mr. Cornell, with all due respect, we have to determine whether or not this person is in fact biased against wind farms.
Okay. He's numerous times under oath told us that he is not.
And until
That is certainly what he said.
He spent an hour and 15 minutes on this, and he hasn't tied it up once. So if he wants to tie it up, let's tie it up. If he thinks he can show bias, let's show him. But until now, we haven't heard a word.
The Ontario Environmental Review Tribunal that you submitted this report to rejected both your testimony and your report, right?
They said that property values and human habitat from a real estate perspective, or words to that effect, were irrelevant under their standard of review. So yes, they did not accept the report or permit me or Mr. Lansing, a Canadian appraiser, to testify to what the impacts are on the human environment in the context of real estate.
So could you try and explain to us why a land value impact report was submitted as something that you said wasn't a land value impact report?
I'll try to do it briefly. Try to answer your question briefly, that is. A market value appraisal of a given property would come to a specific number on a property. The USPAP doesn't say that any appraisal or appraiser opinion has to come to a specific number. It can also speak to whether or not there is a direction in value. For example, the value is higher, the value is lower, the value is influenced by this factor in the local environment, or once you've introduced something into the local environment, it can also provide a basis for paying. That's what I was doing.
The person you did this report with, Mr. Lansing, you also refer to his work in your report and presentation in this proceeding, right?
Yes, he did a fine job on that study up in Ontario, and we communicated, and in fact, I guess you could call it peer review, but he asked me to review that study before he submitted it, and he didn't do that for a client or for any money or as a wind activist or what would you say, lobbyist. He did it for continuing education credits, and he was in fact awarded those credits for doing that very study.
And the study you're referring to is what I got from your attorney, UCLC Exhibit 44, is that correct?
I believe that's the one, yes. He updated it over time, so I'm not sure that's the first one that he actually got the credit for.
Mr. Lansing looked at 12 properties, right? 7 in Clear Creek and 5 in Melanchthon.
Well, as far as impacted properties, yes, but he looked at many more properties than that.
And you recall that he compared actual sale prices to MLS-based averages?
Well, the market medians, that's a fairly typical
Okay.
market measurement tool.
Where do you find averaging in Mr. Bell's book?
I don't have the book in front of me.
Well,
What he did was a resale analysis, which is discussed in Mr. Bell's book.
Okay. You also rely on something in this proceeding called the MPAC study, MPAC, is that correct?
I did give some testimony on that, yes.
And that's the Municipal Property Assessment Corporation, which is the assessing body for the province of Ontario, is that correct?
It's the contract appraiser, if you will, for the province. Yeah.
And you have a summary of what that report says on page 50 of your report in this proceeding, is that correct?
Well, I have a summary of what the relevant part of that study, so the special use standard in the Livingston zoning code is only the relevant part of it. But I did say about the whole study, that's true.
Right. And one of the things you say on page 50, it's, at least what I have here is the third paragraph. According to you, what the impact study says is it empirically measures sale prices to be 25% to 26% lower out to the 3-kilometer setback range and 21% lower prices out to a 5-kilometer setback as compared to median sale prices beyond 5 kilometers. Do you see that? It's on page 50.
I was looking at the PowerPoint, I'm sorry.
Yeah, but you said the same thing in the PowerPoint. Does that sound familiar?
We'll stipulate that that language
We'll
comes
stipulate that it's
from
a-
Okay.
I'm sorry, what was your answer?
Yes, that I did make, I believe that exact statement in my report.
And I believe you testified that the data in this report is their data, the facts speak for themselves, is that correct?
Or words to that effect, yes.
Okay. And according to you, this study is as valid as any and much more transparent, is that correct?
Yes.
And it looked at appropriate sales, is that correct?
For the purposes that they were trying to accomplish and the purposes that they, I believe, unintentionally found, yes.
Okay. And you don't consider this study biased, do you?
Well, they were hired by the Ontario government to do this specific study to address the question of whether or not home values near turbines, or their assessments more accurately, were being unfairly assessed in light of values going down. The Ontario government, that's pretty well known as very pro-green. They approve every wind project almost without fail. If they were going to direct MCAC to do anything, it would be to find that there is no impact, but that's not what the sales data actually showed.
So it's your opinion that this study is not biased, correct?
It's my opinion, despite what appears to be a fair amount of governmental influence and bias, the facts still came out that the sale prices closer to turbines were negatively affected, regardless of what the authors intended to find. Once they put the facts in the report in a fairly transparent and meaningful summary, that's what it showed.
And in fact, on page 50 of your report, you say that the impact study is considered to provide a relevant and reliable overall measurement of value impacts. Is that correct?
Yes.
Okay. What I handed you, Mr. McCann, is the impact study without all the appendices, just the text of the report. Do you see that?
Yes, the narrative, the one with the facts.
Right. Okay. Now, have you read the whole study?
I have, it's been not within the last couple of weeks.
But at some point you read the whole thing?
Yes, sir.
Okay. How long have you been working on your report in this manner?
Well, in the study part of the report, a number of months. I don't remember exactly when I started it. October, perhaps.
All right. So you read the whole impact study sometime during the time that you were preparing the report in this proceeding?
I don't know that I read the whole thing cover to cover again while I was working on this study. I was already familiar with it.
So at some point in time you read the whole thing cover to cover?
Yes.
So you know that the impact study that you're holding is actually in two parts, don't you?
Well, there was a bunch of separate exhibits.
I'm just talking about the report itself. There are two parts to it, aren't there?
I thought there was actually more than that because they also did a kind of a hatchet job on Ben Lansing, which I think they call a separate appendix.
Well, let's try it this way.
Okay.
If you go to page 7, that describes the purpose of the report. And the first part examined, which you've been talking about, whether residential properties in close proximity to wind turbines are assessed equitably when compared to residential properties located at a greater distance, right?
Essentially, yes.
Okay. The second part examined whether the presence of wind turbines in close proximity to a residential property affects the property's sale price, right?
That's what they say, but that doesn't appear to be what they actually did.
Well, if you go to page 10 of the study, and they say here, the study examined 1,157 wind turbines located on 834 properties across Ontario and analyzed their impact on the sale prices of properties based on open market sales in the areas surrounding turbines in the period between January 2009 and December 2012, right? That's what the report says?
Yes.
And the sales of residential properties covered 15 market areas, right?
Well,
That's what the report says?
down separately rather than pooling them, that's correct.
Okay. And then on page 17 of that report, and I think you mentioned this in your presentation, they analyzed, I think you thought this was a very good way to assess impacts at different distances. They analyzed the variation of sale prices for properties located less than 1 kilometer, between 2 and 5 kilometers, and over 5 kilometers from a turbine, right?
Yes.
Right. So that would be, give or take, less than 6/10 of a mile, between 1.2 and 3 miles, and over 3 miles, right?
I'm not sure you got your math right in the 1.2. Repeat that?
Sure. 1 kilometer is roughly 6/10 of a mile, right?
We'll just stipulate that they got the kilometers right.
Okay.
Okay.
All right. Study 1, the tax assessment study, starts on page 15 of that report, right? You see that?
Yes.
Okay.
Now, regarding the equity of residential assessments,
Right.
approximately.
And let's just scoot forward to the conclusion. That's on page 24. The general conclusions in the first sentence there. Therefore, based on the results of this analysis, there is no inequity with regards to distance to the closest IWT, which is industrial wind turbine, and view towards an IWT. Do you see that?
I do.
And obviously you were aware of that conclusion when you submitted this report. That's what you've been talking about today, right?
Well, that certainly refers to the assessment sales ratios and how they got them pretty close to the time-adjusted sale prices in a very tight pattern, and that's what exactly there is no inequity refers to. They're talking about the assessment sales ratios.
Okay. What I'd like to focus on now is, again, the statement in your report that the impact study empirically measures sale prices to be 25% to 26% lower out to 3 kilometers and 21% lower out to 5 kilometers. That's what's in your report. So I'd like to look now at the second part of this study, and that starts on page 25 of the report. Let me know when you're at page 25.
I'm there.
You're there, okay. And this one is entitled, Effective Proximity to Industrial Wind Turbines on Residential Sale Prices, right?
That's what the title says.
Okay. And again, let's just jump forward to the conclusion. That's on page 29. It's the last paragraph.
So there's a lot in there that actually starts laying the foundation for that, such as the significance of
Let's go to the last paragraph.
5 to 10% range. But you want to fast forward to the
Mr.
conclusion and
McCann.
skip over, okay?
Stop. Mr. Blazer's going to ask the question.
Thank you. Page 29, last paragraph. To further confirm its findings, MPAC also conducted an additional analysis using approximately 2,000 sales and resales, following similar logic to the Lansing study. The main differences between the February 2013 Lansing study and MPAC's resale analysis is the sample size and the determination of the increase in the market between resales. Using 2,051 properties and generally accepted time adjustment techniques, MPAC cannot conclude any loss in price due to the proximity of an industrial wind turbine. Did you see that?
I do.
Why didn't you mention that conclusion in your report?
Well, I think I mentioned in my testimony that they ostensibly claim to have studied the value impact, and they would present it as if there is none. But when you look at the actual data, it's quite a bit different than what their words say. I try to be clear on that, and I didn't mean to be at all confusing, but that is what the table in my report shows, is what the actual sales measurements are, not what they wrote in their narrative.
Mr. Blazer, I'm going to try to remind you, stick with this Exhibit 7 and keep rolling with it. The bias, you're looking for a bias.
Mr. Cornell,
Unfortunately, Mr. McCann hasn't, you've got nothing to work off on bias. So is there deficiencies? Is there problems? Are there issues? Is there anything in this report that makes it unreliable?
I'll get there, Mr. Cornell, I can assure you. Right now, this witness has testified at length regarding what this report we're talking about says.
Okay, but this report, MPAC, and this Lansing is in Canada. And we're in Livingston County, and property values are important to Livingston County residents. So we need to focus here.
I can assure you, Mr. Cornell, I'll get there in just a couple of minutes.
Okay.
I can assure you.
The witness is indicating he needs a short break. Is this, I mean, we still haven't even gotten to this report. It's 9:30.
I understand.
And you have questions on the city too. Is this a good time to take a break and to come back? I mean, I think you can come back on the 17th. I mean, we haven't even gotten to the report, and we spent 2 hours, an hour and a half on bias, and we still haven't heard.
Okay. Mr. Blazer, as we pose that question, how lengthy are your questions on the actual report?
Yes. 45 minutes.
How many?
45 minutes.
45 minutes, okay. And
I mean, honestly, I do believe that people in the audience have questions of this individual. And I'm sure that we do. So, we'll wait for Mr. McCann to get back. Well, how is his availability?
Let's go off the record for a minute. I asked him before we started whether he was available on the 17th, where he's going to check, and I haven't heard. So if we can go off the record when he comes back, I'll talk to him. That's it.
Okay. We're going to take this opportunity to recess at this point in time. It appears that Mr. McCann possibly will be back on the 17th. We're working through some scheduling issues. So, there's for sure Mr. McCann, we have on deck. Mr. Steidinger, we'll be looking at next week. And then Mr. Lukian's indicated something with Mr. Punch and Rand. We're still trying to work on a scheduling issue there.
The 23rd, Dr. Punch is scheduled to come in. We will probably fill the 18th with individuals unless I hear something different from one of our experts that makes it available. We'll try and copy individuals as much as we can through on that day. And, Mr. Steidinger, depending on how long this cross takes and everything else goes, we'll be at 17th or 18th, preferably the 17th.
Okay. Just so everybody understands, so we've got meetings next week on the 17th and 18th. They're all going to be back here, 6:30, Bolton Center, Fairbury. The following week scheduled, we have the 23rd and the 25th at 6:30. Again, at this location. So, we'll continue to work through both Mr. Lucahan's witnesses and individuals' testimonies. So, others that are signed up on the sheet that have not testified, be somewhat prepared possibly to maybe fill the night on the 17th by chance, maybe not, or the 18th, be possibly ready to present your testimony. All right? With that, I need a motion to recess, and I've already got one. I bid some. Can I get a second? Iverson seconds.